Good afternoon, everybody. My name is Chris Justice, and I am an employment lawyer with Samfiru Tumarkin. And I'm here, as always, to hopefully answer as many questions as I can in the time permitted. So if you do have questions, definitely get your questions in here and I'll answer them live. It could be anything to do with the workplace. It could be to do with maybe some issue you're experiencing. Maybe you've been let go. You're wondering how much money you might be owed. Maybe you're just starting a working relationship with somebody and you want to see whether or not the contract that they want you to sign is reasonable or has any issues with it. Whatever it ends up being, as I say, get your questions in and I'll do my best to answer as many as possible. Now, on the point of if you've been let go, what are you owed? There's a lot of news about a lot of layoffs occurring. There's layoffs occurring from the CRA. So some organizations who are federally regulated are letting some people go. There's also news across the board in terms of a lot of provincially regulated employers or businesses being let go. Whether you're federally regulated, provincially regulated, in general, your severance entitlements are going to be the same. There is a slight difference in terms of the bare minimum entitlement someone's owed as far as the law is concerned for federal and provincial regulated employees, but the full common law severance, what your full potential maximum is still going to be the same, regardless of whether it's a provincial or federally regulated business. Some of the main factors, as we've talked about on many shows before, have to do with your age at the time you were let go, has to do with how long you've been with the company as well, your position, the money you were making in your role. These are all the main factors courts are going to look at when deciding how much severance is reasonable in someone's position. So again, the fact that you're federally or provincially regulated doesn't really come into the equation. And regardless of who you are, you could get upwards of 2 years of severance. So if you're in that situation, you've been let go or advised of a layoff, definitely give us a call so that we can make sure you're being given an adequate severance package. Most of the time, vast majority of the time, people who are let go, who are then offered a package, are not given a fair package. So all the more reason to give us a shout before you sign anything, before you return anything back to your employer. Otherwise, you could be leaving tens of thousands, if not more, in dollars on the table. Now, before I get into some of the questions, as I'm sure they'll come in, I wanted to talk a little bit actually about layoffs. And when I say layoffs, a lot of people sort of interpret that to mean a termination. What I'm talking about are the situations where you're informed that you're being laid off on a temporary basis. A lot of times, maybe it's due to the economy. People are given letters or they're told by their company that they're being put on a layoff. It's going to be temporary and that the expectation is they'll be called back to work. And a lot of people just assume that companies have the right to do this. But in actuality, a temporary layoff, even one that is potentially going to last for a number of months, is in most cases considered to be a termination at law. And so if you're being put on a temporary layoff without your consent, it's not something you've agreed to before, just know that as an employee, you have an option of treating that temporary layoff potentially as a termination and going after the company for your full common law severance entitlements. So definitely don't want to be accepting a temporary layoff. You don't want to sign any piece of paper saying you agree to be put on a temporary layoff, especially if you don't agree to that. So if you're in that situation where you're being told you need to sign something, definitely give us a shout as well. Most employers, as I say, cannot put you on a temporary layoff unless they have your consent. So that means that you either agree to it at the time they put you on the layoff, or you perhaps signed an agreement, some sort of a contract beforehand, which may give the company the rights to put you on a layoff. But unless one of those two things exists, there is no inherent right for companies to place people on temporary layoffs, even if it is due to legitimate, maybe economic or financially based reasons. So again, you do have options. And just like someone who's been let go, if you've been placed on a temporary layoff, your severance entitlements could as well still rise to the level of almost 2 years of compensation, especially if you're a longer service employee. So just some food for thought, as I say, for those who have been put on a temporary layoff. definitely want to know that you have some options there potentially. With that said, I'll get into a little bit more on some stuff around probationary periods, but I do want to answer some questions from those who have put their questions in. So the first one comes from Sir on YouTube, who's asking, or saying rather, that their former employer is giving them negative references to prospective employers, and what can they do? So the first thing to do is to make sure you have the evidence. So obviously, the more evidence you have about what's being said, the better. So if it's maybe a statement from someone who spoke to someone on the phone, or maybe it's been put in writing and there's a negative reference that's been circulated through an email or a letter, whatever it ends up being, that would be number one, just to gather the evidence. The second thing is proving that the statements being made are not truthful, because then that can rise to the level of defamation. So if you get wind that your employer is saying a bunch of disparaging or defamatory things about you that aren't true, and that's impacting your ability to get a new job, there could be a viable claim for defamation. And then from the defamation, obviously, would flow the damages in terms of loss of reputation, loss of job opportunities. And so not only could you have a claim just for the fact that you were subjected to defamation, but you could also have that additional claim for damages that flow after that. But I think it all kind of starts with being able to show you've got the solid foundation there in terms of proof. A lot of times it can come down to a he said, she said scenario. And even if what you're saying is true, from an evidence standpoint, that can be a much more difficult task to prove, and could come down to a credibility contest. So always good to see if you've got the evidence there, but absolutely, you do have options. There's potential claims there, and some money to be had if the claim's viable. Thank you for your question, though, sir. I've got another one in from Paul on YouTube, who's asking or saying, if they're forced to quit their job because of a toxic work environment and a boss who's a bully, can they still go after compensation? And yes, absolutely. There are many cases where someone isn't formally terminated. Maybe they're not given a letter saying that they're being let go and offered some severance package, but the company is making the work environment, or people within the company are making the work environment so toxic that it's almost like you're being forced to quit. And when someone is being forced to quit or pushed out essentially of the workplace due to toxic or poisonous work environment or behaviors, there can be a claim for a constructive dismissal, which is basically a change to the terms of your employment. And a part of anyone's terms of anyone's employment is the part about being treated with dignity, civility, respect. It's an implied term if it's not written down explicitly. That's a part of every working relationship. You've got to treat your employees with civility, dignity, respect. You've got to maintain a safe workplace. Obviously, as an employer, you can't foster a toxic or poisoned workplace. So if these things are present and are not being addressed by the company, or they're being brushed under the rug, then the employer, the company, has failed in its obligations to have that environment safe, to make sure that you're treated with civility and respect and dignity. So by not doing that, they've breached that implied term. And that's where the claim for constructive dismissal comes in. Even if you may view it like you're quitting, or sort of like almost like a resignation. Again, if it's a forced resignation after everything was done to try to rectify it to no avail, then absolutely you can still go after compensation and potentially get just as much severance as if you had been let go in a more formal sort of situation. But thank you for your question as well, Paul. I've got another one in from Robin, who's saying they work as a seasonal employee. What sort of rights do they have if they aren't brought back when the new season starts? So I think a lot of companies, a lot of employees think that because you're a seasonal employee, that there's probably going to be a different set of rules that apply to you. But the fact of the matter is that if you work, let's say, every summer for a company, and you do that for several years running, and then one year you're told you're not being brought back, and essentially your employment or your seasonal work with that company ends, then that can be very easily treated like a termination, as if, or any other situation. Like say you work full-time Monday to Friday throughout the year, and you're let go, or they say they're not going to renew the contract, or you're not going to be working any longer, of course you're going to be looking at severance. So generally the same rule applies to seasonal employees. It's just that if a seasonal employee is owed severance, they may not get as much because, over the year they're not going to be making as much, but it doesn't mean that they're not entitled to severance. So there'd have to be some sort of contract you signed, some fixed term employment agreement maybe, or something that's set out in writing that specifies or gives the company the ability to end the contract without any of the general obligations it would owe as far as severance. So there are very rare, limited scenarios where it's possible that your time as a seasonal employee could come to an end and you not be owed anything, but most of the time that's not the case, even if there is a contract. So definitely if you're in a situation like Robin and you're no longer working at a company in that sort of scenario, give us a shout because like the others, you could be entitled to a lot of money as far as severance is concerned. I've got another question in from Anna, who's saying that they're on a medical accommodation. They're under severe pressure to go on a formal leave, and their performance is currently being tracked in order to terminate their role. So first of all, you definitely want to keep mindful of ways that they're treating you, because if somebody's on an accommodated role, then there's got to be it's accommodation. There's got to be some accommodation for that. So if you're in an accommodated role, maybe you're on modified duties or modified hours, and they're being critical or overly critical of your performance, and that performance in some way relates to a disability or an accommodation, the company is going to be in a bit of hot water because they could be seen as discriminated against you. So for example, if I have a disability that renders me unable to maybe do as much work as I was doing before, and then the company accommodates me and later criticizes me for not doing as much work as I was doing before, well, clearly that's probably because of something to do with my disability. So if that company then expects me to do more when it knows or ought to know that my disability impacts me in that way, then in sort of a roundabout or indirect way, that could be seen as discrimination. And, good luck to the company to try to get around the idea that you haven't been terminated and you aren't owed severance. So when it comes to performance, especially if it's, impacted by someone's disability, companies would be wise not to go down the path of being super critical of performance. And also, as far as pressure is concerned to go on a formal leave, it seems like you're on an accommodation now. So the question would be, how much of a burden is you being accommodated on that company? Because, sure, a company may want you to go on a leave and just have you come back when you can do 100% of your job. But if it's been accepted, if the accommodation has been accepted, and let's say it's a temporary accommodation, and the company is just putting pressure on you to leave because it just doesn't want to bother with accommodating you for any longer, a day, a week, a month, whatever it is, then that can also put the company in a bit of hot water, open up a can of worms, because companies are expected to accommodate. Companies are expected to take on some burden or inconvenience by accommodating, even if it costs them financially in a lot of cases. They still are required to accommodate. So they would need to show, as I say, that the accommodation now is becoming so costly that it would cause them to have to significantly restructure the setup that they have in the work environment, which is really rare to find in most cases. It's often just more of a minor inconvenience and burden that they just don't want to be bothered with, and that's not enough. So they've got to prove that. Also, again, it depends on how long the accommodation's in effect for and how impactful it is on your ability to do work. So, for example, you work 40 hours a week, but because of your accommodation, you can only put in 5 or 10 hours. There's going to be more of a chance that a company can say, well, we can only accommodate this for so long before, we can no longer do so. But if your accommodation is the difference between 40 hours and 30 or 35, then the company's going to have less of a leg to stand on. They're not going to be able to argue as good that this is a particular burden and that it should only be for a very temporary period of time, the accommodation. So it kind of depends on a number of factors, but the idea that you're being pressured, the idea that they're trying to track your performance, maybe with an eye of getting you out, is running a lot of risk for them. But otherwise, I think it would come down to how the accommodation was handled, how long it's supposed to be for, how exactly does it affect your ability to work? Does it affect it in a big way or a more minor way? And that kind of thing in terms of assessing how long they should accommodate you, and also in terms of assessing how sort of premature they are as far as trying to put pressure on you to go back or suggest going on a formal leave. But definitely give us a call, Anna. It seems like there's a lot going on here, and we definitely want to make sure that we kind of fully canvass everything and give you at least a sense of what all your options are. But I appreciate your question. It's something that is experienced, I think, by a lot of people. So if you're in a situation like Anna, again, definitely give us a shout. I've got another question in from Libby, who's saying or asking if their employer wants them to sign a contract to solidify their duties. Should I be concerned? I've been working 3 years with no contract. I think it depends on the context. I think in general, it could be good to have something in writing spelling out what your duties and responsibilities are, because in that way, assuming you agree to it, assuming it reflects what you have been doing, then there's going to be less confusion later on if they start changing things on you. A lot of times people over the years or months they're at a company notice certain changes to their job, but they don't have a job duty or job description list. So then it can become a bit more challenging to kind of figure out what they were responsible for doing, what was expected of them, and then what the changes were after that. Whereas if you have a job description or a job duty list, you'll know very clearly if later on they remove something or add something to your plate, you'll have a better sense of kind of the black and white, the before and after picture. And that could be important because if the company later on decides to change the terms of your duties or job in a significant way, maybe you're responsible for doing A, B, C, D, E, F, G, and then they take away A, B, C, D, E. Well, you're only left with F and G. You're going to be able to establish probably more clearly that there's been a big change to the terms of your employment. Or if they add on 5 things to your plate that weren't a part of that job description list, you can, more accurately kind of confirm what the changes are. And then depending on how significant they are, you may have options to actually exit the situation and get severance. But there could be a scenario where they're trying to set you up almost. So you want to be careful in terms of what's in this role or this duty list. I think also when they say to sign a contract solidifying your duties, is this just a one pager that lists your duties, or are there going to be a number of other terms in this contract? Right? They kind of frame it in a way where they say, oh, we just want to solidify your duties. But then there's maybe 2, 3, 4 pages of other stuff that's unrelated that is a bit of a red flag, maybe that you're concerned about signing. So, as far as that's concerned, for sure, you'd want to make sure you're not signing anything outside of that. And if you are, you want to make sure you have an understanding of what it is you're signing, because unbeknownst to you, you may sign something not knowing it's a big deal, and then later on you get let go, and now you're looking at nothing in terms of severance or very little. So if they're going to send you something, I would say send it to me. I'll take a look at it. But before you agree or come back with any comments or anything like that, you want to give us a shout so we can kind of arm you with the knowledge you have, and then you can go and respond to your employer and hopefully get that situation rectified. I've got another question in from Sunday on Reddit, who's saying they have to make several reports to HR at their company due to discrimination. The situation has escalated and the company wants me to meet with a third-party consultant. I'm not sure what this is for. Should I agree? What should I do? So I guess, number one, it's good if you've been subjected to discrimination that you make complaints, reports, whatever it is. You want to air your concerns, because otherwise, if it's not documented or written down in some sort of paper or email or document, it could be a battle of he said, she said. So anytime you're subjected to discrimination, there should be a policy you're to follow as far as like company harassment or discrimination in the workplace. You follow that procedure, you let your concerns, your voice be known. And then obviously it should be up to the employer to investigate and, conduct a fair and thorough investigation, getting your side of the story, maybe getting the other witnesses that are involved side of the story before coming out with a conclusion. So in that sense, if you need to work with a third-party consultant, maybe the company has hired an outsider to investigate the matter because it doesn't want to use someone inside that might be biased, which I think is a good idea. So if that's what they're referring to, I think it's fair. You've presented a complaint for discrimination. You're a participant now in this investigation as sort of the main witness, perhaps. And so it's not uncommon for there to be an outsider hired to go in and investigate and sort of get your side of the story, which, of course, if you want the issue to be addressed or rectified, you want to try to be as fulsome in your information so that, again, that allows the company to do its investigation. Now, somewhere down the line, the company may fail in its obligation to conduct a fair investigation, and that could be a problem for the company. But you, as the complainant, want to try to participate to the extent you can. And ultimately, if there's something you're not comfortable with or some other issue that comes up outside of just the fact that there's a third party involved that wants to talk about the situation, I think you're fair to maybe push back or ask about, why they're asking for this or wanting to know this or that. But it seems like this is all coming from you as opposed to you being subjected to the claim or the discrimination claim. So I don't think there's any concern right now, but that's not to say that that may not change. But I would say, try to do your best in terms of participating. And like I say, hopefully the company does the right thing, does a fair investigation, and comes out with a proper outcome. But a lot of times that can go awry, and you may have more options or more of a leg to stand on in terms of your options as far as, exiting the situation, maybe getting severance, possibly other forms of compensation or damages. So I'd say keep us apprised. And if you have any questions as well, give us a shout and we can talk a bit further. I've got a question in from Naveen, who's saying that the short-term disability that's administered by Manulife is but paid by their company. If Manulife denies the claim, who's liable at the end of the day in terms of legal action? So we at our firm, not so much myself, but we do specialize in disability law. So definitely for any of those out there that have short-term or long-term related disability questions, you can also give us a shout to set up a consultation. In fact, I know the next Q&A session after today, after I'm done today, will be a session centered around disability-related questions. So in general, I'd say get your questions in. You see down there below with Martin, just tomorrow, in fact, at 12 Pacific. 10 o'clock a.m. Pacific. So in general, you want to ask your questions to Martin in that sense. But Naveen, as far as your question, what I can comment on is, a lot of times, of course, disability insurers will improperly deny people benefits. It may be the employer that pays the claim, but if Manulife denies the claim and Manulife has the authority to sort of approve or disapprove benefits, you may likely be in a situation where your claim is against the insurer, and you may have to commence litigation, although I know at our firm we do a lot of negotiations before that happens in talking with the adjuster. So it may come out of the company's pocket, but if it's Manulife, the ones who made the decision to not deny the claim, then typically your action would be as against Manulife. But there are other situations where you can have a claim against the employer, and in fact, a claim against both the employer and the insurer. So either way, I would definitely give us a shout. But I know in most cases you're looking at usually the insurer, and that's something that we can definitely help out with either way. I've got another question in from Serena, who's saying they work for a U.S. related company out of Nevada, but it looks like she's living in Ontario. Employers telling him that he can let Serena go at any time because Nevada employment is at will. And that's what my contract states. And that's another misconception. So for those of you out there who work for a US-based company, but you yourself have always worked, let's say, in Ontario, the province in Canada, then even if the company's based out of the US, the prevailing jurisdiction is in all likelihood going to be the province that you live in. And that's very different than at-will termination down south of the border. So it doesn't seem like, in my view, they're correct, Serena. And if you're in a situation like that and you've been let go and you're being told you're not owed any severance because that's what US law says, but you've never actually worked out of the US yourself, absolutely give us a shout, because likelihood is you're going to be deemed an employee in Ontario, and it's going to be the laws of Ontario that govern you, which you and I probably both know are a lot better than the U.S. laws. But that is a misconception that's pretty common. I appreciate the question. coming in. I've got another question in from New Direction on YouTube who's saying they were let go after 3 years as a senior designer. They took a medical leave of absence. The employer is aware of the situation, that the leave is for psychological reasons. And I guess when they were let go, they got offered a severance package of 10 weeks and access to benefits. New Direction's questioning whether it's legal to lay somebody off when they're on a medical leave. They guise it as a restructuring, but you're the only one in your department being let go. And yeah, so it is, I would say, technically possible to be let go on a leave and it not be related to the leave. Although in most cases, that's going to look really bad. And all you really have to do is show that at least 1% of the reason for, being let go was due to medical leave, due to some sort of disability related issue. And so they say it's a restructuring. And again, while that's technically possible, to the extent that you can gather evidence to the contrary, whether it's direct or indirect, I think is obviously going to go a long way in terms of your claim on the discrimination front. They say there's a restructuring. You're the only one in your department being laid off. So I guess the question would be, I assume there are other senior designers that work there. So I don't know how the company would be able to sort of differentiate that to say, well, this is the reason they were the one that we let go when we have maybe multiple other senior designers. It could get tricky for them in terms of trying to justify that. So you definitely want to keep that avenue open. And as I say, it's just 1% of the reason being let go related to that is enough to establish a human rights violation. So you've got that potentially. But obviously, of course, you've got the regular severance request after 3 years, senior designer. They've given you 10 weeks. I mean, technically on the severance front alone, depending on your age, the money you were making there, as well as kind of how the market looks for designer type roles out there, you could get 4, 5, 6 months, maybe more, just on the severance side. So 10 weeks, it's about 2.5 months, maybe a bit less. I would say that there should be some movement on that front. And you would definitely want to sort of look into the human rights thing, because that could be an additional benefit there as far as extra damages are concerned. So in general, I'd say give us a shout so we can determine how much you're owed, but also to kind of talk through the human rights component, which I think is important, and I wouldn't want to sort of dismiss that. So yeah, definitely give us a shout, and anyone in that similar position, it's a red flag for sure. You want to give us a call. But that'll do it for my time today, everyone. Again, I thank you for attending. For those that I didn't get around to answering or any follow-up questions, my apologies. Do definitely connect with me after the fact, or you can always tune in for Q&A. We've got disability coming up next, but after that, there's going to be other employment law sessions, which you can tune in for. But thanks again for everyone's attendance, and do enjoy the rest of your day. Do take care. Bye for now.